whole truth, and nothing but the truth, so help you God. Have a seat.
Good afternoon. Could you please state your full name for the record?
William Kubek.
Do you go by Bill?
Yes.
And where are you employed
At the Lake County Crime Laboratory.
What's your position there?
I am the Assistant Laboratory Director and the Supervisor of Chemistry and Toxicology.
How long have you worked for Lake County Crime?
I have worked there for a little over 11 years.
Have you held any other positions there before being made Assistant Lab Director?
Yes, I started as a forensic chemistry technician, and that was in October of 2013. I then was brought in full-time as a forensic analyst in 2014 in June, and I worked in that capacity until 2019 when I was promoted to Assistant Supervisor of Drug Chemistry, and then I was promoted to Supervisor of Drug Chemistry and Toxicology in December of 2019. And then in May, I was promoted to Assistant Lab Director.
So that's 4 promotions?
Yes, I believe so.
What educational background do you have that qualifies you for the position you currently hold, Assistant Lab Director?
Yes, so I have 2 bachelor's degrees from Tiffin University. Is a Bachelor's of Criminal Justice in Forensic Science. The other is a Bachelor's of Arts in General Science that's focused in chemistry. And I also have a Master of Science in Pharmacy from the University of Florida, where I majored in pharmaceutical sciences with a concentration in forensic science.
When you first came on board as an employee at the Lake County Crime Lab, did you have to complete any training specific to the lab?
Yes, before I could work or complete casework, I completed a year-long in-house training program at the laboratory. I also completed a week-long training seminar with the DEA at their laboratory in Dulles, Virginia.
Do you have continuing education or training requirements for your position at the lab?
So the laboratory does not, they recommend that I complete continuing education. It's not something that I have to do, but I do have to complete continuing education for my certification.
Do you do any optional voluntary continuing education?
Yes.
Such as what?
I go to yearly seminars through MAFS, and I attend many continuing education opportunities as I can.
Did you say through MAPS?
MAFS, M-A-F-S.
And what does that stand for?
That's the Midwestern Association of Forensic Scientists.
Do you hold any sort of...
Yes, I am certified in drug analysis by the American Board of Criminalistics.
Is the Lake County Crime Laboratory accredited?
Yes.
What does it mean to be accredited?
Accreditation is a voluntary process that a laboratory can go through that enables the laboratory to show to its clients or the police agencies that they serve their commitment to quality and consistency.
Have you had an opportunity to testify in court in the field of drug chemistry before?
Yes.
In which courts?
I've testified in Lake County Common Pleas and Lake County Juvenile Court.
Was your testimony accepted as expert in those cases?
Yes.
Are you familiar with the procedure your laboratory employs when evidence is submitted to you for analysis?
Yes.
What happens when law enforcement or some other agency brings an item to the lab?
Yeah, the first thing that they do when they try to submit a piece of evidence is hand it over to our evidence custodians, who will then look over the piece of evidence to ensure that there are proper seals.
Objection, Your Honor. If we're talking, and I just want to be clear, there's already been a chain of custody issue raised. If we're talking about the admissibility of specific tests, unless what the procedure is doesn't in any way answer the question of what was actually done.
I presume he's talking about the procedure, and then we'll talk about what he did in this case, so go ahead.
Fair enough, Your Honor. Thank you.
You can continue.
Sure. So the evidence custodians will look over the piece of evidence and make sure that there's a proper seal. If there's not a proper seal, then they will hand the evidence back over to the submitting officer, and at that point they have the decision to either fix the seal there and resubmit it at that time, or take it back to the police agency and submit it at a later time. Once the evidence is accepted, The evidence custodians will then create an electronic case file in our LIMS system, which is our Laboratory Information Management System. They will take all the information off of the submission form, create this electronic case file, and then print off barcodes that are unique individual identifiers for each piece of evidence that belongs in the case. They will attach those pieces of evidence, or those barcodes, to the pieces of evidence, and then create a physical case file, which is a notification to the disciplines that are requested for testing to enable them to know that testing is requested. The evidence custodians will then take the evidence and transfer it from their possession into our locked evidence cage where it awaits testing.
And that locked evidence cage, who has access to that?
All the employees of the crime lab.
How do you access that locked room?
Yeah, so the locked evidence cage is actually inside of a locked room, a locked area, secure area of the laboratory. So you first have to put in a PIN code to get into the locked room, and then you have to put in another code to get into the locked evidence cage.
And when outside agencies submit any evidence to the crime lab, is there any type of report created as to chain of custody?
Yes.
And does that chain of custody report memorialize what evidence is submitted and by who?
Yes.
And how are you notified when there's an evidentiary item for you to analyze?
Yeah. As I previously mentioned, that physical case file is put into bins that are associated with each section, and we will go through and when we're ready for testing and just take the next case in order.
How many items would you estimate you've tested for the presence of controlled substances over the course of your employment?
Over my career, thousands.
And how do you begin analysis on an item?
The first thing I will do is retrieve the evidence from the locked evidence cage. I will bring it back to my station and transfer it into my possession. I will then check, I will recheck to ensure that the seals are still intact. And if they are, I will continue with my examination. I will then initial and date the packaging before I open it. I will open the evidence, inspect it, describe it on my worksheets, and then I will find a net evidence itself. So that's the weight of the actual substance without any packaging associated with it. I will then proceed with, if it's a solid piece of evidence, I will proceed with FTIR analysis, which is Fourier Transform Infrared Spectroscopy. Once that's completed, I will then take another sample of the evidence and place it in a vial for GCMS analysis, which stands for gas chromatography mass spectrometry.
Do you have a procedure to ensure your testing weighing instruments are working properly?
Yes.
What do you do?
Yeah, we have a quality control testing or procedure that in checking the calibration of the instrument or of the balance before we use it. This consists of taking 4 weights that are calibrated and of known quantity and placing them on the balance and ensuring that the balance reads out to an acceptable window or previously determined criteria. If it does not meet the criteria, that balance cannot be used, and we will then go to another balance.
Do you have a testing procedure to ensure the FTIR instrument is working properly?
Yes.
Can you describe that?
Yes, we will perform quality control on the FTIR. This consists of ensuring that the instrument is working properly when it comes to the energy that it uses to perform its analysis, making sure the energy is similar to what it was the last time we used the instrument. And then we will ensure that the instrument can identify a reference standard. And again, if it does not identify the substance or the reference standard, or the energy is not where it needs to be, we will take it down for service and we will not use the instrument.
And are you testing against known drug samples?
It's not a known drug sample, but it's a reference material.
And then you said you use another instrument, the GCMS.
Yes.
How do you ensure, is there any procedure to ensure that's working properly?
Yes, we run a quality control for that instrument as well. We run a test mix that contains 6 individual drugs that are in one liquid. We run that on the instrument and ensure that it separates out all components of that mixture. And then we run a tune on the mass spec, which ensures that it's operating as it should.
the mass spec, the MS, and GCMS?
Yes.
What do you do with items after your testing is completed?
After we're all finished with testing, we will reseal the evidence, and then we will transfer it into the in the locked cage.
Do the practices you utilize conform to generally accepted scientific principles?
Yes.
Now, at some point, did the Lake County Crime Lab receive evidence from Lake County Narcotics Agency regarding Andrew Nix?
Yes.
Was that evidence submitted through the process that you described earlier?
Yes.
I'm going to hand you State's Exhibit 4, which has previously been admitted into evidence. You do not have to open it up fully, so no need for gloves, but do you recognize that exhibit?
Yes, I do.
What is it?
This is evidence item 1 from case number 22-0699 from the Lake County Narcotics Agency.
And how do you see your writing anywhere on that?
Yes, I have my initials are on the seals on this piece of evidence, as well as my initials and the date from when I opened the package.
Are there any unique labels or barcodes like you mentioned before on that item?
Yes, there's one right here.
And you're pointing at the front of the evidence,
Yep.
State's Exhibit
Yep.
4?
Yes.
And did you test the items contained in State's Exhibit for the presence of controlled substances?
Yes.
Did you memorialize your findings in a report?
Yes, I did.
And are your findings subject to peer review prior to being put actually into a report?
Yes.
Who does that review?
Another analyst in the controlled substances section that has been competency tested in the techniques that were used to analyze this piece of evidence.
Showing defense counsel has been marked to State's Exhibit 14B.
Mm-hmm.
Do you recognize that document?
Yes, I do.
Objection, Your Honor. If they're not going to submit it into evidence, then there's no reason to present them with a document.
Overruled.
What is it?
This is a copy of the report that I generated for this case.
Is that an fair, accurate copy of the original?
Yes, it is.
Where is the original document of your report, your drug analysis report?
The originals are maintained in electronic format, so they are housed at the laboratory in our LIMS system.
And does that report contain your findings after analyzing the evidence that was submitted to you?
Yes.
Thank you. What findings did you make as to State's Exhibit 4?
I found that evidence item 1 at 0.95 grams was found to contain cocaine.
And what schedule of drug is that?
It's a Schedule 2 drug.
And is there a subject person listed on that report?
Yes.
Who is that?
Andrew Nix.
And again, was your analysis, your drug analysis in that report done via the process you previously described?
Yes.
No further questions.
Cross.
Thank you, Your Honor. Let's start with Exhibit 4. There were actually two different items that were submitted into evidence for testing, correct?
I'm not familiar with what item or evidence State's Exhibit 4 was.
Okay, so I'll start with this. On your report, the internal case number, which you assign an internal case number to every item that's tested, correct?
Correct.
So the internal case report is 22699, correct?
Correct.
Okay. And that came out to less than a gram, correct?
Correct.
Okay. Is Exhibit 4 still with him? Do you still have Exhibit 4, or has that been put back?
The only thing I have is the report.
It's up on the table.
Are you familiar with a case number, and actually let me back up, because I think I need to establish a foundation for this. What year did you become the assistant lab director?
This year, 2024.
2024. Okay, and in 2019, you were made head of the chemistry section, correct?
Correct.
Okay. You know who Kimberly Gilson is, correct?
Correct.
Kimberly Gilson tested this before you tested it, correct?
That's correct.
Kimberly Gilson was terminated for violation of lab procedures, wasn't she?
That's correct.
Okay. So you would agree with me that Kimberly Gilson had access and handled the same cocaine that you tested before you got it, correct?
That's correct.
Objection, Your Honor.
Go ahead.
Stake isn't seeking to admit any evidence of the cocaine analysis that Kim Gilson tested. Anything he testifies about concerning Kim Gilson, he has no personal knowledge of. He wasn't involved in her firing. And the drug amount went down by 3/100ths, and it got retested. So this can stand on its own without Kim Gilson.
Your Honor, it goes to definitely to the weight of the evidence. I have not had a chance to investigate why Ms. Gilson, other than the fact it was for violation of procedures, was terminated. The issue of chain of custody has already been raised. Ms. Gilson obviously handled it, and equally obviously will not be here to testify as to what was done, whether it was the same one she put back. That definitely goes to weight. And also, I'll ask one follow-up, but based on the fact that she was performing the same type of test that he was, I'm going to assume that Ms. Gilson was under his supervision as part of his department when she conducted this test.
Okay, overruled. Go ahead.
Were you Ms. Gilson's supervisor?
Yes.
What was she terminated for? What particular violation of lab protocol?
She did not follow protocol when it came to confirming the identity of a substance in a different case. She also altered data.
She altered what?
She altered data in a different case.
Okay. And she altered data, I'm going to assume, to show a positive where there was not one?
No.
She actually went and hid a positive test?
Correct.
Okay. What drug was that?
That drug was cocaine.
If you come back with a negative test, what happens to the sample? If there's 5 grams of it, it does take 5 grams of test, correct?
No, it does not.
Okay. So what happens to a sample when it turns up as a negative test?
It would be reported as negative if it was negative.
What happens to the actual physical object?
The object is returned to the police department.
Okay. You mentioned earlier that at the initial intake procedure, if the evidence is not presented in a sealed container, that they will either send it back to the police to seal it and resubmit it, or reseal it directly at intake, correct?
Correct.
Okay. Isn't one of the reasons for sealing the containers and maintaining control over the containers is to ensure that chain of custody is maintained?
That's correct.
Isn't another reason to do that to make sure it's not tampered with?
That's correct.
Isn't another reason to do is to make sure that there's been no substitutions?
That's correct.
Okay. With regard to exhibit number 4, the sample you tested was less than a gram, correct?
That's correct.
Okay. You've been doing chemistry for, by my math, 20 years or more? And I'm talking professionally, not the undergrads or the masters.
It has been a little over 10, a little over 11
Okay, a
years.
little over 11 professionally, plus a master's, plus an undergrad.
Correct.
All right. So it would be fair to say that you is at this point.
Yes.
That amount that is in Exhibit 4, that's well more than a gram, isn't it? Based on your training and experience and handling of multiple instances of crack cocaine.
No, it's not.
That's not more than a gram?
No.
Okay. You are also, are you aware that there was a 6-gram sample submitted as well?
I am.
Okay. Is your testimony that that is not the 6-gram sample?
Yes.
Okay. No more questions, Your Honor.
Any redirect?
Do you still have exhibit number 4?
Yes.
Place that back right here. Did you review Kim Gilson's report in this matter?
I did. Yes.
Did you notice any irregularities in her report?
No.
Was the data consistent with the data you found in your retesting?
Yes.
If you didn't notice any irregularities in her report, why did the crime lab choose to retest it?
We chose to retest the evidence in order to have someone be able to testify to the evidence. We did not have any suspicion that there was anything wrong with the evidence. We have to have somebody that can testify. So our procedures are evidence is resubmitted for retesting by an analyst who can be present to testify, and we move forward with the testing.
And the functional result is that it has to be retested, and some quantity of the drugs is going to be consumed in order to retest it.
Correct.
And usually, what amount of drugs is consumed when you have to retest it?
It depends on what type of testing is needed. In the instance of a solid substance, very small amounts, like the amount of a tip of a pencil, is needed for FTIR and for GCMS. So I would say anywhere between 0.05 grams, roughly, would be needed for testing.
So roughly 0.05 of a gram.
Yes. If I may, also,
Hold on. Wait for a question.
Are you aware that another baggie involved in this case was tested that weighed more than 6 grams?
I am aware that there was another piece of evidence, yes.
Were you involved in the testing of that baggie of suspected drugs at all?
Not in the testing, no.
No further questions.
Any recross?
You didn't observe Ms. Gilson when she went to the locker and pulled evidence for her test, were you?
No.
You didn't observe her unpack, break the seal and conduct a test, did you?
No.
You didn't observe her put whatever she put back in there and then replace it, correct?
Correct. Did not.
Okay. To be clear, what Ms. Gilson did was to falsify a test, yes?
In the other case, yes. Not in this case, yes.
Okay. Is that a crime?
Hold on. I'm not going to let you.
Objection.
I'm not going to let you get into that situation. I've let you question Mr. Kubek about Ms. Gilson as it relates to her duties and how it peripherally relates to this case, but that's as far as we go.
Fair enough, Your Honor. Thank you. More
All right,
questions?
you may step down. Next witness.
Tyler Meter.
Raise your right hand, please. Swear testimony about gives the truth, the whole truth, nothing but the truth, so help you God. All right, have a seat.
Good afternoon. Could you please introduce yourself for the record?
Good afternoon. My name is Tyler Meter
And where are you employed?
at the Lake County Crime Lab.
What is your position?
I am a forensic analyst,
How long have you worked at the Lake County Crime Lab?
a little over 6 years now.
And what educational background do you have that qualifies you for the position you currently hold?
I graduated from Mercyhurst University with a Bachelor's of Science in Applied Forensic Chemistry.
And when you came to the Lake County Crime Lab and first started there, did you have to complete some training specific to the lab?
Yes, once employed, I completed an extensive, roughly year-long training program that consisted of reading all of our procedures, all of our protocols, watching competent analysts do their and complete supervised casework, as well as being competency tested and proficiency tested.
Could you do any casework independently for that first year?
For that first year, I could not.
Do you have any continuing education or training requirements for your position at the
Ye-
Lake County Crime Lab?
Yes, I do continuing education annually.
And what does that entail generally?
Generally, that entails going to conferences, participating in webinars, going to different training programs that are offered.
Have you had an opportunity to testify in court before in the field of drug chemistry?
Yes, I have.
In which courts?
The Lake County Court of Common Pleas.
Has your testimony been accepted as expert in those cases?
Yes, it has.
How does suspected drug evidence eventually end up with you for a drug analysis test?
When drugs or evidence is submitted to the lab, a police agency will enter in the evidence through our lobby area. Our evidence custodians will accept the evidence in after they ensure that the piece of evidence is properly sealed and labeled. A case file will be created, and then each piece of evidence will be given an identifier that belongs within that case.
Is when evidence is submitted to your lab by police agencies or whoever, is that documented?
Yes, that is documented in the electronic chain of custody.
Chain of custody report?
Yes.
And how is that documented? How does data get logged into the chain of custody reports?
Data gets logged into the chain of custody reports via its unique barcode. Each analyst or whoever touches that piece of evidence will scan that barcode, enter in their unique PIN, and document the transfer in limbs. So at any point in time, that piece of evidence is known where it is at through the lab or who has it at any given time.
Are there particular staff at the crime lab who usually accept custody of evidence that's submitted to Lake County Crime Lab?
Yes, our evidence custodians typically accept the evidence.
And where is the evidence to be tested stored at?
The evidence is stored inside of our locked evidence room, inside of our secure evidence cage.
Who all has access to that room? Any employee at the crime lab?
Just the laboratory employees have access.
And do you scan a card or you put a pin to get in?
We have a PIN code to get into the evidence room and then a PIN code on the evidence cage to get in as well.
Is that automatically logged as well? Who accesses the room for what?
The who accesses the room is not logged. However, when you retrieve evidence, that is logged.
Are you familiar with the procedure for releasing evidence back to agencies who request state testing?
Yes.
What's that like? What are the procedures for that?
When evidence from the lab is sent back, the analyst who completed analysis will seal up the evidence and then send the evidence back to the agency via their unique bin placed in our secure evidence room.
Why does the Lake County Crime Lab create additional labels for evidentiary evidence?
Labels are created so that we are able to identify each and every piece of evidence and we can track the transfers via our chain of custody.
And is there a barcode as well?
Yes.
Can you estimate how many items suspected of being controlled substances you've analyzed over the course of your career?
Over the course of my career, I've analyzed hundreds, if not thousands, of pieces of evidence throughout my career.
And what would you do with a piece of evidence to be tested and analyzed if it wasn't sealed?
If the evidence was not sealed, I would highly document that and then relay that information to my direct supervisor and then the lab director.
Would you proceed with analyzing the substance?
Prior to their direction, I would proceed, or we would send that back to have it properly sealed. That would highly be documented. If it's not sealed, we would not test it.
You would not test it if it wasn't sealed.
Correct.
How do you begin your analysis on an item that comes to you that is sealed?
If the evidence item is sealed, I will go into the secure evidence cage. I will retrieve that piece of evidence. I will scan it into my possession via the unique barcode, and then I will proceed with my analysis.
What's the first step in your analysis?
The first step of the analysis is to, again, make sure that the barcode number on the evidence matches that case number, and again, make sure that that piece of evidence is sealed prior to analysis.
Do you weigh the item after that?
Yes, I will remove the evidence item from its packaging, only one evidence item per time. I'll remove all the packaging from the item, and then I will obtain a net weight of the item.
And do you have any procedure to ensure your weighing instruments are working properly?
Yes, prior to weighing any piece of evidence for the day, I will perform quality control on our balance to ensure that it is operating properly.
And what's the next step after weighing the items to be tested?
After obtaining the net weight, I will then IR analysis for your transform infrared analysis, infrared spectroscopy analysis, I'm sorry.
And do you have a procedure to ensure the FTIR instrument is working properly before you use it?
Prior to using it every day, I will also perform quality control to ensure that that instrument is operating properly.
Do you use any other instruments to test the item for the presence of drugs?
Yes, following FTIR analysis, I will perform GCMS analysis, gas chromatography, mass spectroscopy analysis, and prior to using that instrument, I will also perform quality control to ensure that that instrument is operating properly.
If the first instrument machine works at FTIR, why do you test it with the second instrument?
Per our policies and procedures at the Lake County Crime Laboratory, we double confirm any solid dose evidence, so FTIR and then GCMS for our double confirmation.
And what do you do with the items after your testing is completed of them?
After my testing is complete, I will put it into my secure evidence location. I will write down my findings in a report. Once the report is finalized, administratively reviewed and released, I will then seal the evidence and send it back to the agency.
Do the practices you utilize conform to generally accepted scientific principles?
Yes.
Now, at some point, did the Lake County Crime Lab receive evidence from Lake County Narcotics Agency concerning, East Lake PD concerning engineers?
Yes.
Lake County Narcotics Agency, was it from Lake County Narcotics Agency?
I believe it was from Eastlake, or I'm not sure for the.
Would it refresh your recollection to look at your?
Yes, if I could reference my report, I would.
Did you write, at the time you wrote your report, were you aware of what agency submitted the testing to the items to be tested?
Yes, and on the barcode, the case barcode, evidence barcode, it also says the police agency that submitted the evidence as well.
Your Honor, may I? Anyone wants to read that document off? That document you just looked over, refresh your recollection.
That document was not the report
Oh,
that.
my apologies. And has your memory been refreshed as to which agencies submitted the items for you to test?
Yes.
In this case, what agency was that?
East Lake PD.
Okay. So I'm now going to hand you State's Exhibit A, 8. This has not been admitted to evidence yet. Do you recognize State's Exhibit 8?
Yes, I do.
Could you please put on the gloves in front of you and take the item out? Also, how do you recognize that item initially?
I recognize this piece of evidence by the unique barcode as well as the date and my initials that are on the packaging.
And can you, did you test State's Exhibit 8 for the presence of controlled substances as well?
Yes, I did.
Did you follow the procedures you mentioned earlier as to weighing the item?
Yes.
What about as to using the FTIR machine?
Yes.
And did you also check to ensure your GCMS instrument was working properly?
Yes, I did.
All right. And you don't have to take it out any further than that.
Okay.
But do you recognize anything else about the packaging of the item?
Yes, so for all of the packaging, I will put the barcode, my initials, and date on everything that I owe time, so I'm able to ensure that this piece of evidence came from this outer packaging, and all of which was sealed prior to my analysis.
And after you analyzed State's Exhibit 8, did you reseal it?
Yes, I resealed it, and then I sent it back to the agency.
And did you memorialize your findings in a report?
Yes, I did.
Sorry, too many papers. And the report, do you recognize that?
Which exhibit is that?
It will be State's Exhibit 14B. Is it 14B? Yeah, 14B.
Your Honor, I'm going to object. I brought up the prosecution that I was not provided with those specific identified exhibits prior to trial. They responded they would not be moving to admit those.
We're not seeking to admit it, and he was provided in discovery with this report.
Your Honor, I was provided a ton of information in this report, but I specifically mentioned, and I said to the prosecuting attorney, 13 and 14, you did not provide me with the specific marked exhibits, so I don't have to go looking all over the place for them, and they said they're not going to admit them.
Well, I'm not going to let him admit them.
I'm not seeking to admit it.
Duly noted, Your Honor. Thank you.
Are your findings subject to peer review prior to being put into an actual report?
Yes, they are.
Who does that review?
Another competent analyst will do a technical review. A technical review consists of looking over all of my generated pages of data, all of my notes, all of my worksheets to ensure that I properly relayed what I had on my notes into my report.
And where is the original report? Is that the original?
The original report is stored in our LIMS, Laboratory Information Management System, electronically.
And why don't you keep the original report outside of the lens?
Any printed copy would be deemed uncontrolled, so we keep our controlled official document electronically stored in LIMS.
Is that a fair and accurate copy of the original?
Yes.
And are there distinguishing numbers on that report, as you mentioned earlier, that identifies this case?
Yes, the unique case number and my initials are on this report.
Does that report contain your findings after analyzing the evidence that was submitted to you?
Yes, it does.
And what were your findings as to State's Exhibit B?
State's exhibit contained 6.62 grams net weight of cocaine.
And was your analysis done via the processes you previously described here today?
Yes.
Stay removed for evidence of State's Exhibit A, Your Honor.
Objection, Your Honor.
All right, 8's admitted.
Nothing further.
Cross-examination?
Thank you. Please leave number 8 up there with them. I'm going to start with questions about that. The unique case number you made reference to, that's 22-000674, correct?
That's correct.
Okay. Now, if there was a retest reason, there would be a separate indication where it was signed out and signed back in, right?
Retest on the chain of custody, there would be, yes.
Okay. Would that be on the packaging as well? Would that be noted?
On the packaging, if this were a retest, another analyst date and initials would be on the packaging.
Okay. I'm going to hand you what the government has marked Exhibit 4. Can you tell me if there is a retest indicated on Exhibit 4?
I did not participate in the analysis of this item.
Understood. I'm just asking, there's no difference in procedures for retest between one case number and the next, though, is there? It's always indicated on the packaging, correct?
Not necessarily on the packaging, you would have to look at the report to see who released a separate report. However, based on what I see on this piece of evidence, it was opened by 2 different analysts on 2 different dates.
Thank you. And actually, I'm going to keep you there for a second. Until you go and sign out the item for testing, you don't know, I'll say it this way. You don't have any direct interaction with any evidence until you go to sign it out for testing, correct?
That's correct.
Okay. So whether someone checked it in or not, whether it was sealed or not, if you don't have any personal knowledge of that, correct?
That's correct.
Okay. You only know what you did.
Yes.
All right. So you mentioned the importance of making sure it's sealed, correct?
Yes.
And you said that you would not test until, if you went to the drawer, pulled out whatever item you're supposed to test and saw the seal was broken, you would not test and you would report that to a supervisor, correct?
Correct.
And at your level, that would be heavily indicated on the report, correct?
Absolutely.
Okay, to your knowledge, if a police department drops off an item for testing and it is not properly sealed, it never gets into the system, correct?
To my knowledge, it will not be accepted into the laboratory.
Okay, and the notes only start when something enters the laboratory, correct?
To my knowledge, yes.
No more questions, Your Honor.
Any redirect?
Nothing further, Your Honor.
All right, you may step down, thank you. Next witness?
Stay rest, Your Honor.
All right, does the defense wish to present any evidence?
We will not be calling any witnesses, Your Honor, and I realize it's essentially the same standard, but I'd be remiss if I didn't make a motion for Rule 29 dismissal. There are serious gaps in the state of Ohio's case. We have misidentification by Sergeant Frank of the individuals in the vehicle and what they were wearing. We have hearsay problems scattered around this case like landmines. The individual who supposedly made the call and supposedly made the buy and supposedly provided the results of that buy, SA 91, is nowhere to be seen. We've got huge issues with regards to chain of custody of that, not only from the time that SA 91 received it backwards, but we've got chain of custody issues from the time Detective Frank put it in to evidence at Eastlake forward. We've got an issue with the testing and a gigantic credibility / change of custody issue with regards to what happened when Ms. Gilson handled that. She was terminated for an act of dishonesty and for tampering with results. We have problems with the source of the information that led to the call of the phone. The objection which I will renew now regarding all statements made regarding the stop forwards. We have inconsistencies with regards to whether or not license plates were called out. We have inconsistencies on the color of the vehicle. There's not much that actually links up one-to-one here, Your Honor. I understand that on Rule 29 that the preference is given to the non-moving party, but there are huge pieces missing here, and they all center around the fact that the most important person to this case, the CI, is not here. So for those reasons, I will make, and I'll be brief on my Rule 29, I ask the court to dismiss.
Response?
The state has provided substantial evidence, competent evidence for this court to find sufficient to support a conviction on both counts. Sergeant Frank said the person was wearing red pants and a black shirt, which is correct. All of the arguments that defense counsel made go to weight, not to admissibility. His argument as to great gaps as the vehicle is sometimes calling it gold versus tan. I think at some point he said shooter. The defendant claimed that everything in the car was his. The transaction of his trafficking of cocaine is on video. All of the times line up. He got caught with the phone he made the drug deal on. And this case should go to the court for facts. And in the light most favorable to the state, there's absolutely enough evidence to convict the defendant on both counts. Thank you.
All right, based on the evidence in the applicable law, I'll overrule the motion for acquittal. And is the defense resting?
Defense is resting, Your Honor. Thank you.
Okay. You ready to close?
Your Honor, prior to closing, can I put one thing on the record? I just want to
Sure.
clarify something Mr. Cook said here in court. He had indicated that he did not receive state's exhibits, I believe it was 14A and 14B. That is inaccurate. Full discovery was provided to Mr. Cook back on the 10th day of October. It was the same day that he was appointed as an attorney of record by this court. I believe what Mr. Cook was referring to was that today the state did not provide him again another copy of the same exhibits that were being marked and used at trial. I just wanted to clarify that full discovery had been previously provided to him. Thank you.
All right, I understood that to be what he was saying, that he didn't receive a 13 and 14B, I think. That was the extent of it. You got the discovery, but you did not. That's what you were talking.
Yes,
you
Your
guys
Honor.
were talking about the same thing, right?
Yeah,
Okay.
the specific and
All
the
right, that's-
specified, when he says 13A, I didn't even know
All
what
right,
it looked like.
that's what I understood. That's what I understood.
Thank you, Your Honor.
So let's reconvene in about 10 minutes, okay?
once to Special Agent 91, once to Detective Fawcett, and once to officers at the scene. In an effort to convince officers, he even states that the drugs were found in the door where he was seated. Perhaps nobly, he didn't want his fiancée to take the blame, who was also in the car. Now he attempts to shirk responsibility for his actions when faced with the consequences. But the defendant had knowledge. He had clear use and access to the door of the car where the cocaine was found right next to him and where he surely placed the cocaine. Court heard the booking clip. The defendant was adamant on video about what he's saying and that everything in the car was his. There's no hesitation on his part in admitting that everything in the car was his. And when he says that, obviously he is not referring to the radio in the car, not any legal items in the car. He's claiming the illegal items. He's claiming that the cocaine that he knew they were going to find in the car was his. And he told officers at the scene that they'd find anything they found in the car was his before the car had even been searched. As for count two, trafficking in cocaine, if a picture says 1,000 words, the video of State's Exhibit 1B says at least 10,000. We heard the phone call setting up the drug buy. The defendant was identified by his voice, by Detective Courtroom, as the person answering the call. We saw the video of the buy as it happened, both before and after the buy as well. We saw the still of a textbook hand-to-hand drug sale. And then and then the defendant was caught with more cocaine after his drug sale in the same clothes, sitting next to the same fiancée we saw in the CI's video, in the exact same gold Toyota Avalon that he just sold cocaine out of. The marked money found in his pocket matches all the serial numbers of the marked LCNA funds that were given to the CI. The cell phone that was seized from the defendant has call logs of the defendant as Tom. The times in the call logs and the evidence shown to the court match and are consistent with the controlled buy operation. And the defendant knowingly sold 0.95 grams of cocaine to Tom. The only thing that evidence demonstrates that he had no knowledge of was that he was unwittingly trafficking cocaine to a confidential informant, and that he was also about to get arrested. State would respectfully request the court return guilty of that verdict on all counts. Thank you.
Thank you, Mr. Crook.
Your Honor, quite literally, this case starts with hearsay. It's not about what happened that day. It's about what evidence the court has to make a determination as to the weight of the evidence if it's beyond a reasonable doubt, each and every element of these two charges. There is no way that we can determine, one, SA 91 didn't have that phone number, didn't provide it. Nobody, in fact, had that number without it otherwise being given by a third party, and that statement is hearsay. The phone ring test, hearsay based. The admission of the call, hearsay based. The voice ID. The officer, to his credit, testified honestly that he would not be comfortable with just those 11 seconds of voice testifying or swearing a warrant out that I know who this is. If you tell me, hey, this is his voice, do you recognize it? Oh yeah, of course I recognize it. Yeah, I know him from way back when. There's nothing, testified, there's nothing unique about his voice. It's not high, it's not low. There's nothing in the phrasing. There's nothing there to work with in 11 seconds. It would in any way give credibility to a blind voice ID. Would renew my objection on the search already. One of the things that came out today was that from Detective Frank, that the second he got on the scene, that my client was already in custody. This is news to me. I don't believe there's been anything related to Miranda on that either. So I think there's an admissibility issue there. Chain of custody is like, I'm not going to go in detail. I already made the point during Rule 29, Your Honor. I have never heard of a CI who's a junkie, who's a drug addict, being left alone in the same house where they busted him for drugs and made him a CI, being left alone in there, and then left to go walk. That video shows, and it shows what it shows, and the answer is not a hell of a lot. Phone's down a lot. Phone is not facing hardly anything, which is horrible English, but the point remains. Barely see the person who they say is Tom. I don't know. You can barely see, you can't see my client's face. You can't see anything but the legs. To be clear, what Detective Frank testified to was white shirt, red pants, not black. And he also had black pants on the driver, which the video clearly shows is wrong. We've got the CI himself, who miraculously didn't appear. He got his get out of jail free card, and he took the hell off. He had every reason to want to have a successful buy here, and that required turning over cocaine. What does that video show? It shows some wadded up hunk of something sitting in an African-American gentleman's hand. That's what it shows. It is. We can't tell from the video, and we don't know that wrapper was the same wrapper that was given to SA 91. There is an absolute lack of credibility. The fact that we've got the crack that is part of the trafficking was handled by someone that was terminated for procedures, and she was the saw her handle it. No one knows what she did with it. We don't know. We do know that she was terminated for dishonesty. My client said he took full responsibility for what was found in the car. Video showed it. That much is true. However, he never takes responsibility and never admitted, and nobody testified that he admitted to trafficking. So the state makes a big deal out of I take full responsibility for finding the car. That's only one of two counts. That has no applicability to the trafficking. What we know is that a CI apparently made a phone call. The number came from the CI. We have no way of verifying, other than other people saying what that CI meant. And again, Your Honor, that is speculation. What he meant, the only person that can tell us what he meant is him, and he's not here. And again, Your Honor, the bottom line is there's so much that is out of either the control of law enforcement, that there's no evidence presented by law enforcement, or that they have no way of knowing absent violation of the rules of evidence, i.e. hearsay, to say that they've met each and every element beyond a reasonable doubt. The trafficking's got to go, Your Honor. They don't have enough. As far as the possession goes, the simple fact is we filed the motion to suppress. We were unsuccessful in that. That is what it is. But we've still got, even with that, Detective Frank says, I haven't seen this. I haven't looked at anything since the day I put that in the locker. We've got no link from the locker to the actual testing agent, who was the last gentleman to testify. I understand they describe what the procedure is, but there's no one to tell us. There's been no arguments as to any other reason why that information should be accepted, and we don't even know who the people are in the middle. That's got to count against weight, and it's got to count heavily. It's not the defendant's job to disprove things like chain of custody, to disprove things like reliability, to disprove things I mean, the best evidence rule, to prove that they found it through other ways other than hearsay. It's the state's job. They did not meet their burden, so I'd ask my client to be found not guilty on both counts, Your Honor.
Thank you, Mr. Hurd.
The defendant doesn't need to have admitted to trafficking. We saw him on video traffic cocaine. The video speaks for itself. There were multiple officers on the scene observing what was going on, who saw him leave the McDonald's, who swiftly followed him, and then performed a traffic stop within 2 miles. Defense counsel wants you to believe that the CI planted evidence, but it's outrageous. It is much more likely that the man who just got caught with 6 grams of cocaine next to him and was seen on video selling a bindle of cocaine was the person who sold it. There was no lighter heard in the CI's video. You saw and heard how the CI was acting. He's not acting like someone who just smoked crack or was planting drugs. As immediately once he bought the drugs, he was nervous about having them and wanted to turn them over immediately. We saw the bindle of drugs in the video, and in evidence which the state has given to the court, you will see a receipt next to the small bindle of cocaine which the defendant sold to Thomas Sutton. A phone test will always be hearsay, at least the video of it. Detective Courtroom testified about what he did. That's the best it can ever be. And the phone number that Detective Courtroom wrote down in April